The Supreme Court has delivered a crucial interim order on the Waqf Amendment Act 2025. While it refused to stay the entire act, the court has paused some of its most debated provisions. A bench led by Chief Justice B.R. Gawai and Justice Augustine George Massey made it clear that certain clauses cannot be operated without proper checks and mechanisms. The controversial requirement that a person must be a practicing Muslim for 5 years before creating a waqf has been put on hold until states frame clear rules, as the judges warned that without guidelines, this could lead to arbitrary decisions. The court also stated provisions that gave district collectors or government officers the power to decide disputes on whether waqf properties encroach on government land, stressing that this violates the principle of separation of powers and that such issues must be decided by tribunals, not the executive. At the same time, the court did not interfere with the rule requiring registration of waqf by user, noting that this provision existed in earlier laws between 1995 and 2013 and was not a new imposition. On the issue of non-Muslim members in waqf bodies, the court allowed their presence but capped the numbers. No more than 4 in the Centre Waqf Council and no more than 3 in state waqf boards, while also noting that as far as possible, the CEO of a waqf board should be a Muslim. Reactions have been sharp and varied. Petitioner advocate Anas Tanveer said the Supreme Court has given protection on key provisions like the 5-year clause and collectors' powers. Advocate Reena N. Singh pointed out that earlier the collector could even take possession of waqf lands, but that is now stayed. Political voices like Congress MP Imran Pratapgarhi hailed the verdict as a relief against what he called government attempts to grab land. Religious leaders too welcomed the order. Maulana Khalid Rashid Farangi Mahali of the All India Muslim Personal Law Board said the stay on key sections is encouraging, while Sayyid Qasim Rasool Ilyas, member of All India Muslim Personal Law Board, added that most of their demands, including removal of the 5-year clause, had been accepted to a large extent. The centre, represented by Solicitor General Tushar Mehta, had argued strongly against any stay, claiming that the amendments only address the secular management of waqf properties and do not affect religious freedoms. He also reminded that before 2013, non-Muslims were not allowed to create waqfs, and extending that right had raised concerns of misuse. President Draupadi Murmu had given assent to the bill in April this year after heated debates in Parliament. In short, the court has allowed the Waqf Amendment Act to function but clipped some of its most controversial wings. The registration of waqf by user remains intact, but the 5-year faith clause and the collector's powers have been put on hold, setting the stage for a wider debate when the final verdict is delivered.